Hello, and thank you for joining our webinar, Navigating Form I-9 Challenges. I'd like to begin by introducing our presenters. We'll first start with Sathab Abo, Immigration Counsel and Senior Product Director at I-9 Advantage. Sathab has acquired extensive experience in immigration law, management, and client development. She interacts with immigration officials on business immigration and Form I-9 matters. Sathab also advises clients and informs audiences on Form I-9 trends and regulations. Next, I'd like to introduce you to Cornelius Wyatt Jr. Cornelius is a management and program analyst with the Public Relations and Education section with U.S. Citizenship and Immigration Services Verification Division in Washington, D.C. Mr. Wyatt educates the public as he promotes various programs on behalf of the Department of Homeland Security. I will now hand off our webinar to Cornelius, who will begin in just a moment.
And while we're waiting for things to get started, I just wanted to thank I-9 Advantage for hosting today's webinar and also having U.S. Citizenship and Immigration Services to be a part of today's session as well. Once again, my name is Cornelius Wyatt. I work within the Verifications Division, which is a component within U.S. Citizenship and Immigration Services. And just to give you a little background as to what it is that we do, we manage over the Form I-9. So we manage over the Employment Eligibility Verification Form. We also manage over E-Verify, which we'll talk a little bit about today as well. That allows employers the ability to electronically verify the work authorization of their newly hired employees. We also manage the SAVE program, Systematic Alien Verification for Entitlements program. So the SAVE program will allow benefit issuing agencies the ability to verify the status of foreign nationals before administering various types of public benefits. So for example, the Social Security Administration, the Department of Housing, before they run applicants through, before they administer various types of programs, benefits, they will run the applicants through our SAVE program. So I see everything is working, should be working on my end, so we're going to go ahead and get started with today's presentation on the Form I-9. In order to control illegal immigration in the United States, in 1986, Congress passed what is known as the Immigration Reform and Control Act, also referred to as IRCA. So what this law basically does is it forbids employers from knowingly hiring individuals who do not have work authorization to work here in the United States. And as an employer, if you're looking to obtain more information about the regulations, that can be found, IRCA information can be found in Section 274A of the Immigration and Nationality Act. So when we're talking about the Immigration Reform and Control Act, these are the individuals who may legally work in the United States. Okay. So you have your citizens of the United States. These are individuals that may have been born, naturalized, or derived their citizenship status. Non-citizen nationals of the United States. These are your individuals that are typically born in American Samoa, including the Swain Islands. These individuals, they owe allegiance to the United States, but they have certain rights while here in the U.S., such as they don't have certain rights, like they cannot vote. So those are your non-citizen nationals of the United States. Lawful permanent residents. Lawful permanent residents are those individuals also referred to as having green card status or permanent residency status. And then you have your aliens that are authorized to work in the U.S. Your aliens that are authorized to work, they could be in a particular non-immigrant working classification, such as an H-1B, H-2B, various types of working classifications that could fall under aliens authorized to work. The employment verification. Now, to comply with the Immigration and Nationality Act, employers are required to verify the identity and employment authorization documents of their newly hired employees. So anyone that has been hired after November 6, 1986, it is the responsibility for the employer to make sure that they're verifying the employee's identity and work authorization. As the employer, you should also make sure when completing that you are also retaining the Form I-9 for each individual that was hired after November 6, 1986. And we'll talk a little bit more about what is the retention period of retaining the Form I-9. You also want to make sure that you refrain from discriminating against individuals on the basis of actual or perceived national origin, their citizenship, or immigration status. And so we'll talk a little bit more about this as we move forward in terms of our relationship with the Office of Special Counsel. The anti-discrimination provisions of the INA prohibits 4 types of unlawful conduct. So you have your citizenship or immigration status discrimination. So this is when that employer is discriminating against employees based upon their citizenship or immigration status. National origin discrimination, document abuse during the Form I-9 process. The employee has already shown documents proving that their work authorized. Employer, you're requesting additional documents from that employee. That would be considered document abuse during the Form I-9 process. And then there is retaliation. If the employee has filed any type of action or complaint against the employer and they're seeking to retaliate, that would be a form of discrimination. So within our verifications division, our outreach branch, we work very closely with the Office of Special Counsel. And as an employer or employee, you can actually contact the Office of Special Counsel and your calls can remain anonymous. So the anti-discrimination provisions of the INA are enforced by the Department of Justice Civil Rights Division, Office of Special Counsel for Immigration-Related Unfair Employment Practices. Okay. So let's say, for example, if you're going to terminate an employee, but you want to know a little bit more about your legal rights before doing so, contact the Office of Special Counsel. There's someone there that will be able to assist you as well. We also have, well, the Office of Special Counsel also has on their website the do's and don'ts when it comes to the employment verification process, which is a really great resource link. And also, once you receive today's PowerPoint presentation for all those that are registered, you'll also receive some additional links coming from the Office of Special Counsel that will be able to assist you. Okay, so the new Form I-9. You may have already heard that the new Form I-9 is coming out soon. So USCIS is going to publish the revised Form I-9, the employment eligibility form, that should be published by November 22nd, 2016. Employers may continue to use the current version until January 21st, 2017. After January 21st, all previous Form I-9 versions will be invalid. And so for more information, you can stay up to date with the Form I-9 by visiting our I-9 Central website off of USCIS's website. Here we go. We're looking at the Form I-9. So we talked about the new Form I-9 that's coming out really soon. So here's a snapshot of what the current form looks like. And just note that when you look at the new form, you'll see some new updates and enhancements made to the form. So for example, you'll start to see on the new form, on each particular fill-in, you'll be able to click on a helper text that will assist you with completing the form. So if you have specific questions, you'll no longer have to contact customer support. You may not need to contact our customer support. The new Form I-9 will have helper text on each field that will allow you to complete that particular field. So as we look at the current version of the Form I-9, the form page is 2 pages, and these are the pages that you can retain on behalf of the employee. A lot of times employers want to know, should they retain the instructions, and you're not required to retain the instruction pages. And so we're going to talk about each section of the Form I-9 broken into 3 sections. It's important to note that all U.S. employers must have a Form I-9 on file for all of your current employees. So for your company, once again, will be required to complete the Form I-9. I'm going to ask for assistance in terms of going to the next slides, being that it seemed to disappear. So all U.S. employees, there we go. Okay. So all U.S. employees must have a Form I-9 on file for all of your current employees. The exception to this rule is you're not required to have a Form I-9 on file for your employees that were hired on or before November 6, 1986. So you're not required to have a Form I-9 on file for these individuals. And you also may decide to delegate the authority to complete the Form I-9 to a responsible agent. However, you will retain liability for any errors. So if you're deciding to outsource the Form I-9, to have someone else complete on your behalf, any errors that are made on that form, you as the employer would still be liable for that. Here we're looking at a list of the acceptable documents. You want to make sure that your employees have the list of acceptable documents when they're completing the Form I-9. As the employer, your employee can provide you with one document from List A. List A will establish the employee's identity and employment authorization. If he or she cannot provide a document from List A, well, they can provide a combination of one document from List B that will establish their identity and one document from List C that will establish employment authorization. You should never request or ask your employee to provide you with a specific document. Okay? So once again, you want to make sure that they have the list of acceptable documents. Okay, so now we're looking at Section 1 of the Form I-9. This is the employee's information and attestation. So Section 1 is completed by the employee. And as you see here, this is where the employee can enter their last name, first name, any other names that have been used. They should go ahead and enter that information in Section 1. Their street address. You should not enter a P.O. Box address in Section 1. It should be the street address. Okay. The Social Security number. The Social Security number is not mandatory only unless the employer is participating in E-Verify. If the employer is participating in E-Verify, they must provide the employee must provide his or her Social Security number. The email address. The email address is used just in case that employee would like to receive confirmation from that employer if that employer is participating in E-Verify. So the email address will provide that employee with updates in regards to their case. And they can also provide their telephone number as well. The employee will attest under penalty of perjury by checking one of the 4 boxes stating what their status is here in the U.S. Are they a U.S. citizen of the United States, a non-citizen national, a lawful permanent resident, or an alien that is authorized to work? You want to make sure that you're only selecting one of the options that's provided, and make sure that you're signing and dating Section 1. So the employee will complete Section 1 at the time of hire. Okay. So it should be completed, once again, no later than the first business day of employment for pay. A lot of times employers want to know, well, can we go ahead and have that employee complete Section 1 before the first business day of employment for pay? The answer to that question is yes, as long as there has been an offer of employment and accepted by that employee, you may begin the process of completing the Form I-9. In Section 1, you'll also see where it says Preparer and/or Translator Certification. And when you look at the new Form I-9, there's going to be additional fields for this. So we're going to give it, there's going to be even more space if someone is looking to assist someone with preparing or translating Section 1 of the Form I-9. You would just need to sign and date Section 1. And by signing and dating this information, the preparer or translator is attesting that Section 1 is true and correct to the best of his or her knowledge. Okay, so in Section 2, this is the employer or authorized representative review and verification. Section 2 is completed by the employer. This is completed within 3 business days after the employee begins work for pay. So if someone was hired on Monday, then by close of business Thursday, Section 2 should be completed by the employer. A lot of times employers want to know, well, can we go ahead and abbreviate when using Section 2 and entering information? And for most common documents, such as the Social Security Administration documents, you can just write in SSA in the field. As the employer, you must examine original documents, and the documents must not be unexpired. So you can no longer accept expired documents when completing Form I-9. Okay, so when you're looking at Section 2 of the Form I-9, the employee, based on the document the employee will provide, you'll go ahead and enter the document title. So, for example, if he or she provided a lawful permanent resident card, that would be considered a List A document. So you would fill out the List A section accordingly by entering the document title, which would be lawful permanent resident card. The issuing authority would be the U.S. Department of Homeland Security, and the document number that is on there, and if there is any expiration date. Same business rule applies with List B and List C. If someone provides you with a state ID document, that would be considered a List B document, such as a driver's license, and a List C document could be a Social Security card, and you would enter that information. You also want to make sure that you sign and date in the bottom of Section 2. By signing and dating this information, you attest under penalty of perjury that the documents you reviewed appear to be genuine and relate to that individual. If at any time the document does not appear to relate to the individual or appear to be genuine, you should not certify that information in Section 2. Provide that information back to the employee, or you can actually contact our Office of Special Counsel if you have specific questions about legal rights. Examining documents. You know, we don't expect for employers to be document experts. So when you're looking at documents, you must accept the document presented to you by the employee, and as long as it reasonably appears to be genuine and relate to that individual, you should go ahead and accept it. You should not be holding that document up to the light, trying to determine if, in fact, this document is legit. Once again, the document must be original, and photocopies are not acceptable. You can accept copies of a birth certificate, a certified birth certificate. You can accept a copy of that. Okay. So you may choose, well, copying your documents. As an employer, you may decide you would like to make photocopies of an employee's document. But keep in mind that if you're making photocopies of someone's document, you must do so for all of your employees, regardless of their actual or perceived national origin, their immigration status, or you may be in violation of anti-discrimination laws. Once again, you can also reach out to the Office of Special Counsel in regards to your rights if you feel as if there are any concerns regarding making copies of documents. Section 3 of the Form I-9 is the reverification portion. Okay. Reverification and rehire. So you would complete Section 3 if you would complete this section if you're going to rehire an employee. If someone has left your company and it's been within 3 years of the date of the initial execution of the Form I-9, you can go ahead and complete Section 3, or you can complete a new Form I-9, Section 3 information, and retain that with the original Form I-9. So you don't want to discard the original Form I-9. Or if someone were to change their name, legally change their name, and you want to be able to update biographic information about that employee, you can go ahead and complete Section 3 of the Form I-9 and retain that with your records as well. In regards to your rehires, USCIS does recommend completing a new Form I-9 for your rehires. You also want to make sure when you're looking at your rehires that the documents that may have previously been presented are in fact still, they have not expired as well. So when should you be re-verifying your employees? You should not re-verify anyone that is a U.S. citizen. So if someone has provided you with a U.S. passport, or if they have provided you with their permanent resident card, they're in a lawful permanent resident status, or a List B document, an identity document. Someone's identity does not change for Form I-9 purposes. So U.S. citizens that have provided U.S. passports or a passport card, someone that has provided you with a permanent resident card, or a List B document, you do not re-verify them for Form I-9 purposes. In certain circumstances, if someone is a lawful permanent resident, you would re-verify a lawful permanent resident only if they presented you with an I-94, that's the arrival departure record, with a temporary I-551 stamp, or a foreign passport with a temporary I-551 stamp on a machine-readable immigrant visa. So basically what that means is someone is immigrating into the United States. They have an arrival departure record that they received at the port of entry, and on that arrival departure record, that I-94 document, there is a temporary I-551 stamp. That stamp lets the Department of Homeland Security as well as employers know that this individual is a lawful permanent resident. That stamp would be valid for about 1 year, and that employee can work and travel with that stamp. It's just before that stamp expires, they need to be able to show that physical permanent resident card, the actual permanent resident card, or receive another stamp in their passport. Okay. Usually, in most circumstances, you would re-verify someone when they've provided you with an employment authorization document that has an expiration date. So, for example, if you're hiring non-immigrants to work for your company and they're under, let's say, H-2Bs, H-1Bs classifications, then those classifications has expiration dates on them. So you would be re-verifying those individuals. Or if someone has an employment authorization document, those documents has an expiration date, and so upon expiration, that individual needs to be able to obtain either an extension or be able to show something from the list of acceptable documents that would allow him or her to continue to work. If you're correcting mistakes on the Form I-9, if you ever discover that you need to correct a mistake on the Form I-9, on the existing Form I-9, you can choose to correct the existing Form I-9 simply by lining out the incorrect portions and enter the correct information and initial and date the correction. Or you can complete a new Form I-9. If you're completing a new Form I-9, you want to make sure that you're retaining the original form. You should also attach a short memo to both the new and the old form stating the reason for your action. And the reason we ask that you do that is just in case if for any reason you're no longer in that position and someone else is looking at the Form I-9, at least they can see why it was, why there were changes that were made in terms of corrections. If you discover that the Form I-9 is missing, you want to immediately provide the employee with the opportunity to complete a new Form I-9. And you should allow that employee 3 business days to provide you with the acceptable documents. You don't want to backdate that Form I-9. So that date that you presented it to that employee is the date that you would sign in the certification portion. Storage and retention of the Form I-9. So there are various ways in which an employee can store the Form I-9, and it's really based on your business needs. So Form I-9 must be on file, once again, for all of your employees, all of your current employees. You want to make sure that you store the Form I-9 securely in a way that meets your business needs, whether it's on-site, at a storage facility, or electronically. A lot of times employers want to know, well, can they go ahead and store the Form I-9s with other copies of that employee's information together? And the answer to that is yes. Any employment work authorization information related to that employee, you can go ahead and store that information. Also, you may also want to consult with ICE. ICE has a program referred to as Image, and they also work directly with employers that are enrolled and using E-Verify, and they can assist you with that your Form I-9 concerns as well. They have auditors that can assist you with those types of concerns. You also want to ensure that only authorized personnel has access or have access to the storage Form I-9. So you want to make sure that when completing the Form I-9 or using the Form I-9, only those individuals that should have access to this personal information should be able to obtain this, and you should be storing it in an area where it is secure. You want to make sure that the Form I-9 is available within 3 days of an official request for an inspection. So if for any reason the federal government needs to do an audit or you're being contacted to present your Form I-9s, you want to make sure that they're available within 3 days of an official request for inspection. So retention of the Form I-9. So how long should you, the employer, retain the Form I-9 for? Well, you should be retaining the Form I-9 for 3 years after the date you hire an employee, or 1 year after the date, after that employment date terminates. And what I mean by that is if that employee is no longer working for your company, then that's when the retention period starts. So it's 3 years after the date you hire an employee, or 1 year after the date employment terminates, whichever is latter. So in this example, we're stating that John Smith was hired on November 1st, 2014, and on July 5th, 2016, his employment was terminated. On November 1st, 2014, we went ahead and added 3 years, which makes it November 1st, 2017. And then his termination date, July 5th, 2016, we added 1 year. And the retention period is November 1st, 2017. We also have this information, the formula, on our website, on our I-9 Central, and we'll talk more about that. So here's some information on some of the resources that we provide on our website. We have I-9 Central. I-9 Central is a great resource tool. If you're that person that handles the Form I-9 and you need to get information, or sometimes you feel like you're getting conflicting information, I-9 Central is what you need to have on your desktop. This is available in both English and in Spanish, and it's a great resource tool that will allow you to click on a specific topic, helping you navigate to get the answers you need for a specific question or concern. We also have our Form I-9 multimedia resources. So by visiting our multimedia resources page, you can obtain our Form I-9 vignettes. So we have a Form I-9 vignette that will allow you to watch each section of the Form I-9. So if you have specific questions, you can watch either each section, or you can watch the entire webinar on demand video that we provide. But the vignettes is a great resource, a great training tool. So it will break down each section of the Form I-9 and give you the information you need to know about that particular section. If you cannot make any of our public webinars, we do offer Form I-9 webinars on demand, which you can watch 24 hours a day, 7 days a week from anywhere in the world. We also have outreach. We provide free customized webinars in our outreach branch. We develop partnerships with a lot of amazing businesses and agencies, and we would love to be able to work with you and be able to also provide customized webinars, whether it's Form I-9 or on E-Verify. We can also supply content for your newsletters. So if you have a blog or a newsletter and you want to obtain content information, we can provide you that information as well. A lot of businesses, what they're doing, and a lot of agencies, they're linking, they're taking our E-Verify logo, placing it on their website, and having a place where their stakeholders can link to official information coming from the Department of Homeland Security. And we would love to be able to share the E-Verify logo and information with you, link, so that your stakeholders can obtain information, updated information. You can also add E-Verify to your job announcements as well as My E-Verify. One of the things that, if you're already using E-Verify, you need to be familiar with My E-Verify, which is a great resource tool for the public. So through My E-Verify, the public can obtain information on their rights. They can also now go online, self-check their own information before going to an employer that uses E-Verify. So a lot of businesses is putting the My E-Verify link on their website for job seekers to be able to go ahead and confirm their own work authorization through self-check. Our customer service, E-Verify received the highest rating for customer service for all federal agencies. So we would love for you to contact us if you have any specific questions or concerns about E-Verify or Form I-9. You can contact our customer support, or you can send us an email, as well as visit our website for additional guidance. So as we conclude today's webinar, I just wanted to state that immigration law can be complex, and it is not possible to describe every aspect of the process. So today's presentation provides a basic information to help you become generally familiar with the rules and procedures. And for more information on the law and regulations, you can visit our website as well. So what I'm going to do now is turn it back over to I-9 Advantage.
Thank you so much for that really helpful, informative presentation. We're very grateful for your knowledge. We thank you for partnering with us. And I would like to answer a question that appeared very early on in the presentation, and that was whether or not we would be providing the slide, the presentation slides themselves, as well as the audio to our attendees. And we are, in fact, going to provide those at the completion of the webinar, and we will also answer any questions that we are unable to get to this afternoon. And we encourage people to continue asking questions. We've received quite a few. We're going to talk a little bit about our software our electronic I-9 software solution. And once we wrap up with that, I'll just take a couple of moments, and then we'd like to get to your questions, and hopefully we are able to provide as much insight as we can given the remaining time that we have. So with regard to our I-9, our electronic I-9 solution, we have 3 platforms that we offer to employers and to partners as well. One is I-9 Advantage. It creates a secure, it allows for employers to create and securely store flawless I-9s. The second is I-9 Medic, which enables employers who have existing paper I-9s, what we call legacy I-9s, to digitally convert them and correct those paper I-9s. And then finally, the mobile-enabled remote hiring, we call that I-9 Remote. Given the trends in the employment industry, whether it is automotive or IT or medical, all of those industries, we are seeing a significant increase with remote hires. That is, individuals that are employed by a given company but may not come to the brick and mortar or the headquarters to begin employment. They may be hired remotely in another state, they may be placed at a client site, etc. So given the trends and the increase in that, we of course have an I-9 remote solution that allows you to use several different options when it comes to assigning an agent, an authorized agent, to complete the Form I-9, namely Section 2 of the Form I-9 on your behalf, and to ensure that that is then returned to the employer to verify, to correct, and then of course that is stored electronically as well. So our system is 100%, it is 100% cloud-based, and we're going to go ahead and talk about some innovative features that the system allows and provides to users. The I-9 Advantage system in general allows the convenience and flexibility that an electronic solution delivers. There's walk-up usability, which includes, of course, the system's use and intuitive features. It allows everyone to become an I-9 expert. It is wizard-driven and very user-friendly. There's an increased efficiency and productivity that comes along with using I-9 Advantage solutions. Our software solutions reduce the time that you would otherwise spend processing the Form I-9 by at least 75%. Our solutions integrate with HR platforms. For those of you who are familiar with a number of different HR solutions, for those that have applicant tracking systems and existing HR platform solutions, we integrate with those as well. And of course, there's an instant E-Verify submission. We partner with E-Verify. It is seamless as far as the users are concerned, and the end user is as far as the end user is concerned. The E-Verify submission automatically pushes all of the values that you enter into the electronic I-9 through to E-Verify with some customized options for each user, depending on how you set up your E-Verify MOU as well as your location. And as I mentioned, it is 100% paperless. The complete I-9s can be done via desktop, laptop, tablet, or even a smartphone. So as I discussed, again, this is one of our platforms, the I-9 Advantage platform, which creates these error-proof I-9s, and it eliminates the risk of government fines with precise data validation and error checking. It streamlines the I-9 process to reduce the risk of employee discrimination with standardized processes, knowing that certain individuals would only present certain documents. And of course, it eliminates the possibility of document abuse as well. So as you can see here, I won't go through all the details, but we will provide you with this presentation shortly after the webinar for you to review at your leisure. And of course, for those clients of ours and partners of ours that have existing I-9s, those legacy paper I-9s, many of them are looking for solutions on how to clean those up. And our I-9 Medic tool is perfect for that. It eliminates the risk of human error. It and the preparation time for an audit from weeks to minutes. It self-corrects these archived forms I-9, and as a result, of course, it decreases your risk of fines. The corrections are done directly to the Form I-9, and then it produces, of course, a log of sorts that helps you identify where the errors occurred and what types of steps you can take to remediating those forms. And then finally, the I-9 remote, as I mentioned, allows you to use an authorized agent or one of 12,500 trained notaries. We partner with Notary Network across the country, as well as some other solutions, including PAN, and allows, of course, employers to select authorized agents of their choice as well to complete Section 2 of the Form I-9. So more importantly, let's get to questions and answers. I'd like to take a look at some of the questions that we've received from our audience. So bear with me for a moment. We'll share some of the questions, and please feel free to go ahead and address these as you'd like. And if there are any complex matters or some questions that we're unable to get to, as I mentioned earlier, we will certainly provide some answers at a later time.
Sure.
The question here is, why are P.O. boxes not allowed for the address?
P.O. boxes are not allowed for the address based on the fact that, and this is something that many employers have also asked as well, they want to be able to, if ever audited, you want to make sure that the employee has an address where they can show a place of residence for employment. If they cannot provide a residence address, then they can provide information on a general location as to where their address is located. Our M274 guide provides more information on that. But from a legal perspective, the Office of Special Counsel would be able to provide more guidance as to why you cannot provide a P.O. box address.
Thank you, Cornelius. That's a great answer. The next question is, with the new form, will we have to attest, let's see, a little unclear, but I will allow the individual, we can reach out to this individual and ask if they can clarify this question at a later time, but let's move on to another question. You mentioned that I-9s could be stored with other employee documents. Do you mean their hiring paperwork, including, for instance, W-4s, employment applications, offer letters, medical documents, etc.?
Yes, the Form I-9 can be stored with other documents related to that employee's file. How much information an employer wishes to store the Form I-9 with is at their discretion. One of the things that businesses can do is they can speak with an ICE image representative within their state just by visiting ICE website and typing in image, I-M-A-G-E, and these are the individuals that could come out and do the auditing process for you. And if you have specific questions about how much information you should be storing with the Form I-9, they would be able to address that for you.
Great, thank you. Another question is, when the employee, what do we do when the employee ignores the instructions and fills in Section 2? I find that kind of comical because, as we know, they are not permitted to complete Section
2. That's correct. The employee does not complete Section 2. So if I understand the question, what does the employer do if that employee doesn't complete Section 2?
Yes, correct.
Right, yeah. So if that employee doesn't complete Section 2, then the employer doesn't have to worry about it because they are not required, and the Section 2 is only for the employer, not the employee. Yeah, the only section of the Form I-9 that will be completed by the employee is only Section 1.
Great. So the next question is, when correcting Form I-9, does the employer sign off on the correction, or does the employee need to sign off on the correction as well?
Right. The employer would sign off on the correction. They would line out the error. They will put a line through the error that is made, and they will date and put their initials next to it. And they will also include a reason why this correction was made. So they'll have an attachment with that as well.
Okay. And Cornelius, I'm sure you received quite a few questions with regard to rehiring and the steps that an employer must take as it relates to the Form I-9. So I think this is a good question, and it's as follows. When an associate is rehired for the third time, the rehire date has already been filled out in Section 3 on page 2 of the I-9. So do we just add a second page 2 and fill out the rehire date on that, or do we need to have the employee fill out another Form I-9, and do we keep both I-9?
Right, good question. So for the rehiring process, what you would need to do is, and both of those answers are correct, you can actually add additional page, or you can have that employee complete, the employer can complete a new Form I-9 and enter information in Section 3 and make sure that they're always retaining the original versions or original versions with any updated versions as well.
Good. Another question is, what happens when a permanent resident card expires? I think this is an interesting question because we've talked about this and touched on it a little bit, but it is a recurring question for a lot of employers. I think there is some confusion as it relates to the permanent resident. So what happens when a permanent resident card expires?
Right. When a permanent resident card expires, you do not re-verify these employees. So they would fall into the list of individuals that you do not re-verify. If it is the initial hire, that employee must be able to provide a document that has not expired. But if that individual is already working for your company, you do not have to worry about re-verifying someone's document, a lawful permanent residence document that has expired. They do not get re-verified. And that information we've actually updated. It's updated on our website on I-9 Central just so that employees can have that information in writing as well.
Cornelius, to piggyback on that previous question about making corrections, the attendee wants to clarify and says, so to clarify, when making corrections to Section 1, can the employer make the correction, or does the employee have to make the correction? Since, again, it's Section 1. So I think there's a very clear distinction here, and we should probably be clear about that.
And it could be both. There are situations where there may have been an error made by the employee. The employee may no longer be working for that particular company. Therefore, that employer can go ahead and line out that information, make the appropriate correction if needed, date it, and add a memo as to what was done on there. If that employee is still working for that company and they're available to make the correction, they can go ahead and do the same thing. They can line out the information, add their initials, date it, and provide that information back to the employer.
Okay, great. Another question is, so just to confirm, we do not re-verify a citizen even when his or her List A document is expired.
That is correct. U.S. citizens, you never re-verify for Form I-9 purposes.
Correct.
That information is updated on I-9 Central and in the handbook for employers as well.
Okay. Another question is, sometimes I see our employees entering USCIS numbers in the document number section for the List A document. Is that fine? Or do we need to actually enter the document number from his or her permanent resident card, usually beginning with an LIN or MSC, etc.?
Let me see if I understand. For List A, this is for Section 2 of the Form I-9. For document number, they were entering, what was the number? I'm sorry?
The USCIS number?
Okay. Okay. So for the document number, yes, so the document number would be, it can be the USCIS number. That can be a USCIS number. So if someone has an employment authorization document, that is considered a List A document. That employment authorization document will have a number. They can go ahead and enter that as the document number for under List A category.
Okay. Someone asked a question with regard to, take a look, we're still getting quite a few questions, so I'm trying to filter through these as effectively as possible. Question is, I'm interested in knowing how long we should retain the I-9 document after an employee has been terminated. We're told that after 3 years, we no longer have to keep the I-9.
That is correct. The retention period, as long as that employee is working for your company, you should continue to retain the Form I-9. After that employee leaves the company, that's when the retention period starts. So it's 3 years from the hire date and 1 year from the date of termination. Whichever is the latter date will be the retention date. On our I-9 Central website, we also have the formula there that will assist the public with those types of questions.
This is a good question, Cornelius, and this sort of addresses the state versus federal distinctions. As we know, there are oftentimes state laws and legislation that may not necessarily mirror federal laws, and then there is a contradiction. So the question here is, California has a law protecting employees from discrimination when updating I-9 documentation, which was incorrect or falsified at the time of hire. Are there any other states that apply this?
Right. In regards to speaking to state laws, I wouldn't be able to provide that type of information, unfortunately. Form I-9 is a federal form that should be used by all employers across the nation. But in terms of state updates or guidance, I would say the Office of Special Counsel may be able to provide additional policy-related information based on other states. So I would encourage anyone to contact the Office of Special Counsel for additional guidance.
Okay. I'd like to take one last question, Cornelius, if you don't mind, and then we will conclude our webinar for today. The question
Sure.
is, can a stamp be used in Section 2 in place of the company name and address? So rather than a company completing those individual fields, are they permitted to use a stamp that automatically includes the company name and address?
Sure, good question. From an auditing standpoint, I mean, as long as Section 2 is filled out completely by that employer, that should suffice. However, from an auditing standpoint, this is something where Immigration, Customs, and Enforcement, where their image department, being that they're the ones that would work with employers to help make sure that, you know, for any auditing related concerns that they're in compliance, you should contact Image to see if, from an auditing standpoint, would you be penalized if using a stamp in place of filling in Section 2. That's a great question, and I will also look into that for future reference for other businesses as well.
Good. Well, Cornelius, that concludes our presentation for today, and we'd like to thank our audience for joining us. We're very grateful for the time that you've spent with us this afternoon. We're also grateful for our attendees and the questions that they've provided. We hope that this information has been beneficial to all of you as employers, as partners, both of large companies and small companies, as this, of course, impacts all of you, the Form I-9. And we will get to your questions, and we hope to provide you with a copy of the webinar today as well as the audio. and answers to the questions that are outstanding that we've not had an opportunity to get to. Is there anything else that you'd like to add, Cornelia?
Once again, thank you for once again having USCIS participate in today's overview. Just to let everyone know, once again, we do offer customized webinars, and thank you, and that's all I have to say right now.
Great. Have a wonderful day. Thank you all.
Thank you.